Thank you guys for taking a few minutes out of your day to review the latest updates on bullying and how we handle those in the school setting. This is a presentation put together by the Department of Education for the legal obligations to address harassment, intimidation, and bullying. Definition of cyberbullying means bullying undertaken through the use of electronic devices. Electronic devices include phones, cell phones, PDAs, computers, email, instant messaging, text messaging, and websites. Here in 2011, originally enacted 2005, amended 2011 to include cyberbullying and acts that do not occur at the school or school-sponsored events. 2016, most recently added a 48-hour time frame to initiate investigation and 20 days to initiate appropriate interventions, and a procedure for referral when appropriate for counseling. And the principal or designee shall inform the parent or legal guardian of the availability of counseling or support services. To define harassment, intimidation, and bullying, it is any act that substantially interferes with a student's educational benefits, opportunities, or performance, and if the act takes place on school grounds, at any school-sponsored activity, or school-provided equipment or transportation, or at any official bus stop, and has the effect of physically harming or damaging a student's property, knowingly placing a student or students in a reasonable fear of physical harm to the student or damage to the student's property, causing emotional distress to a student or students, or causing a hostile educational environment. If the act takes place off school property or outside of a school-sponsored activity, this law still applies. If it is directed specifically at a student or a group of students, or has the effect of creating a hostile educational environment, or otherwise creating a substantial disruption to the educational environment or the learning process. Every year, teachers and counselors must be made aware of this policy and must be trained on how to implement it at the beginning of the school year. Thus, the reason for the video. Notice of harassment, intimidation, and bullying prevention programs to promote awareness of harmful effects of bullying must be provided to students and parents at the beginning of the school year. So we will do that as well. Principals of all middle, junior, or high schools or the principal's designee shall investigate harassment, intimidation, bullying, or cyberbullying when a student reports to any principal, teacher, or guidance counselor that physical harm or a threat of physical harm to such a student's person or property has occurred. New 2016 shall immediately inform the parent or legal guardian of a student involved and inform them of the availability of counseling services. So that means if student A says student B has been bullying them, we got to report that to both parents immediately. Following any required investigation, the principal or designee shall report the findings along with any disciplinary action to the director of schools and the chair of the school board. The school systems, the LEAs, which stands for the Local Educational Authority, must submit to the State Department a report with number of harassment, intimidation, bullying, or cyberbullying cases brought to the attention of the school officials during the preceding year, including the findings, the number not initiated within 48 hours, and the intervention, and the number where the intervention was not initiated within 20 days, the type and manner in which all cases were resolved, including disciplinary action, and then we are encouraged to review the policy every 3 years and submit a copy of any changes to the commissioner in a timely manner. And then the TDOE must report a similar thing to the General Assembly. Retaliation, reprisal, prohibition of retaliation or reprisal by school employees, students, or volunteers against victims or witnesses. If you have school employees, prohibition. So you are free from retaliation. School employees, students, or witnesses who have reliable information that a student has been subject to an act of harassment, intimidation, bullying, or cyberbullying are encouraged to report to school officials. school employees who promptly report acts of harassment, intimidation, bullying, or cyberbullying are immune from a cause of action for damages arising from any failure to remedy the reported act. That's important for you guys. Once you report it, you're free and clear. All you have to do is to report it. You do not need to investigate it. We recommend that you do not investigate it. Stay out of the kids' drama. Turn it over to the admin and let us deal with that. Okay? Again, you want to cover yourself, report what you know within 48 hours, preferably sooner so that we can jump on it when it happens. Hazing is also a similar topic to this. Hazing is defined as any intentional or reckless act on or off school property by one student acting alone or with others against another student that endangers or induces or coerces a student to endanger the mental or physical health or safety of that student. This does not include customary athletic events or similar contests or competitions. Limited to actions taken and situations created in connection with initiation into or affiliation with any organization. We cannot haze our freshmen as they join a new organization. Each school system has to have a written policy against hazing. Policies will be distributed and made available to each student at the beginning of the school year. And during the first month of the new year, we will set aside time to discuss the policy and the ramifications as a criminal offense and the penalties that will be imposed by the LEA. Laws around harassment. You got Title VI, the Civil Rights Act of 1964, Title IX, the Educational Amendments of 1972, and the 504 Act of 1973. Some federal guidance from two different Dear Colleague letters from the feds. Harassment creates a hostile environment when the conduct is sufficiently severe, pervasive, or persistent so as to interfere with or limit a student's ability to participate in or benefit from the services, activities, or opportunities offered by the school. So what does severe, persistent, pervasive mean? Severe, the actions may include physical assault or severe threat of bodily harm. The more severe the conduct, the less the need for a pattern of behavior to establish illegal harassment. Persistent, the behavior happens repeatedly. Pervasive, the unwelcome behavior is everywhere within the school environment. And, or do we have harassment going on all throughout the school? Typically, one-time behaviors don't fall underneath the umbrella of harassment unless it's deemed to be severe. Harassing conduct can take many forms: verbal acts, name-calling, graphic written statements, including the use of cell phones and the internet. Can be conduct that may be physically threatening, harmful, or humiliating. It does not have to include intent to harm, be directed at a specific target, or involve recent incidents. A lot of times people say, well, I wasn't bullying her, that wasn't my intent. It's not the intent of what you're doing, it's how it's received by the victim. And it does say it does not have to include repeated incidents, but there you got to have the severe piece come in. The school is responsible for addressing harassment incidents it knows about and things that it should reasonably have known about. So when we know about it, when it happens in plain sight and widespread or well known to staff and students, we should be aware of that. And then other situations, the school may become aware of misconduct that would trigger an investigation leading to the discovery of additional incidents that, when taken together, could create a hostile environment. So what we should know about, if something happens in the hallway during class change, we should know about it because we should have staff members there. Okay? We ran into some hot water here my first year's principal when we had a fight in the courtyard before school. Back then, we did not have a bus duty person in the courtyard. For some reason, we thought it was good to have 500 kids in the courtyard and no adults there. Well, lo and behold, one day a fight broke out. Kid got hit in the head. That kid already had a traumatic brain injury, so mom was less than happy about our lack of oversight. Since then, we now have a person out in the courtyard because we reasonably should have been known that there was a fight there. Investigation. There's 4 parts in 4 phases to an investigation: the complaint intake, the gathering of evidence, we evaluate the evidence, and then we have an investigative report. This is all the things the admin do. This is not what you as a classroom teacher does. As a reminder, the classroom teacher and counselors report it and document that you report it. Better to do it through email because now it's time-stamped as well. We're going to document and acknowledge the receipt of the complaint. We're going to get it in writing. We're going to review it. We're going to review our policies: bullying, cyberbullying, harassment, hazing, and discipline. And we're going to determine if the allegation applies. So if the kid says, "Oh, I'm getting bullied," are they really getting bullying under these policies? Is it yes? Is it no? If it's no, then we're done with that investigation, and we're going to write that report up. If it's yes, we're going to move forward. Decide whether or not we need to call DCS or law enforcement. Is this above our scope of jurisdiction? We're going to look at prior discipline records, and then we're going to review prior investigations or complaints. We're going to determine who to interview. We're going to document the interview. We're going to have witnesses. We're not going to record the interview, but we can take notes. And we're going to determine if there is a need for interim action during the pending investigation. How do we keep the kids safe in the meanwhile? We're going to interview the parties and the witnesses separately. We don't ever do those in groups. We're going to avoid to ask leading questions. We're going to make sure they're age-appropriate questions. We should look for tone. We should watch our tone and avoid accusatory language. And then we need to remind the students about how to report retaliation if that occurs, and get any other documentary evidence, such as web pages, screenshots, text messages, emails, all that kind of good stuff that we can get. If the student wants to remain anonymous, that is their right. However, we need to tell them they can limit the ability to handle the complaint. Sometimes it's hard for us to deal with the situation if you don't tell us what's going on. It can also lessen the disciplinary action against the accused, and remind the parent and student that we only give out information on a need-to-know basis. And even if the kid wants to remain anonymous, we still have to investigate. Now we're evaluating the evidence. We look for corroborating evidence, look for inconsistencies and impossibilities, hearsay. We at the school level can use hearsay much more so than the court of law can. It is admissible for us. And then we determine if we need to re-interview any witnesses or gather any other evidence. Write the report, put it in writing. Should be thorough and objective without opinions. Just state just the facts on that one, please. And should include recommendations for action. Following any required investigation, the principal should report the findings and discipline action taken to the superintendent and the chair of the Board of Education. Notify the parents, both the complaining parents and the accused parents. Put it in writing, being careful about privacy. Remind students and parents of retaliation, how to report it, and also remind staff about retaliation. And then review discipline policies and procedures and make sure we're staying consistent with the disciplinary action. One note about staff retaliation: when you know something about an incident, don't tell the other kids about it. Sometimes we have to say things that seem obvious. We've had times where teachers will say, "Oh yeah, Johnny's up in the office telling him what happened, or telling on so-and-so." Well, now you just outed Johnny in that situation. So now you've opened him up to retaliation. So be smart about that. Other things to consider: is there a need for a safety or behavior plan? Do we need to separate the parties? Is there a need for additional conduct training of staff or students? And we need to keep our records, and we need to notify the board attorney if needed. Here's a few websites for additional resources. Feel free to pause the video and write these down. More websites and a couple of the Dear Colleague letters. To review, here are the high points. We got 48 hours to initiate the investigation, 20 days to implement the appropriate intervention. We need to have a procedure in place for referring appropriate counseling. Employees who promptly report are immune. If you don't report, you're not immune. Required investigations: when we have those, we've got to report the findings and the disciplinary actions to the director of schools and the chair of the Board of Education. Thank you for your attention to this video, and I hope you have a great rest of your day. Thanks.